Dear colleagues, we will start now the next session of the 7th Competition Forum. I'm happy to welcome all of you. Let me introduce you the participants of our panel discussion. So first is Leonid Kozachenko, People's Deputy of Ukraine, chairperson of subcommittee for the policy of agricultural complex of the committee for and co-chair of Interfaction Deputies Association, Protection of Economic Competition. Iryna Bulhakova, the judge of Cassation Court at the Supreme Court of Ukraine, professor of the technologies of law. Kürşat, also Kürşat, Vice President of a Turkish competition agency. Cosmin, Belacurencu, member of the board. He represents the Council for matters of competition in Romania. Mikulík, the head of the section of appeals of the Department for Protection of Competition of Czech Republic, and Mr. Nagorny, he is the deputy chair of Civil Council at the Anti-Monopoly Committee. It's for the 7th time when we organize for AMCU this next forum on the matters of competitive policies and law. It was actually the idea appeared a long time ago yet in London, and we discussed the matters of the legislation on competition, its development, respective judicial court practices, and I'm pleased to offer the floor to Leonid Kozachenko. He's been working for many years on development of the competition legislation. He participates in all discussions taking place in both AMCU and in the Ukrainian Parliament, especially when these discussions are devoted on further development of competition policy and law. Well, you have 10 minutes. Dear friends, today we have a very important event. The subject matter of this discussion has a big importance over the development of the economy of our country. This event is also important because of participants. We have here leading experts from all around the world. The countries shared with us their expertise, the countries which certainly set a very important example for us. Without competition, there is no progress. It's very important to realize for Ukraine, because Ukraine used to have, in the Soviet times, absolutely different economic system and system of economic management, which is absolutely different from the competitive economy. And it's not easy to really switch from one system to another. So we have to learn from the lessons learned by those who have managed to pass this difficult path of reform. Unfortunately, the current parliament has adopted just one law dealing directly with the competition. We have there 7 more draft laws which I believe have to be urgently reviewed by the Parliament, because all of their provisions mean the implementations of the modern global experience in the area of competition. My major concern is that whenever we have any political discussions or professional associations of the citizens, by some reasons nobody mentions or wants to change the state's monopolies. Take this painful issue for Ukraine: energy independence, problems with oil, gas, coal. We have natural resources given to us by the God. They are quite sufficient to fully support ourselves and to arrange for export of this product, and we cannot do that just because of these state-owned monopolies. Plus, these monopolies put huge burden of the debt on our shoulders. We are talking about hundreds billion hryvnias. But this business all around the world is very profitable. And when you ask a question, how come the gas extraction, natural gas extraction, is owned by 80% by the state monopoly? Why don't we implement tender, make sure that we provide for proper concentrations, let's let foreign companies come in? We used to be number 5 in the global rating, for instance, in chemical production of the chemicals. Now we are on the place number 72. Let's do it. And the answer is no, we cannot do that because that will create unhealthy competition with private companies, because they will reduce the price by 20%, and the state-owned companies will not be able to stand this competition with them. We need to last for at least 3 more years to pay back the debts made by former corrupt government, and so we need to keep the monopolies in place. That sounds really surprising for a specialist, but that's true that we have to deal with. We need to see how other countries have done that. We have other monopolies, not only natural resources. I could tell you a lot of interesting things about oil and coal, but actually the situation is very similar to the one with the natural gas. We have problems with logistics. One of the advantages of our country is our geographic position, but we never use this advantage again because of monopolies. Ukrainian railroads, huge problems just because they don't want to demonopolize the structure. They do not want to give up. There are many good examples around the world. Take United Kingdom or the United States. What you can do with a railroad to make it really a tool to use the advantages that are unique for Ukraine, because we are a bridge between Europe and Asia. We have access to the seas, rivers, etc., etc. Monopolies exist even in such areas as production of weapons. Well, private companies are not authorized to enter this market to make some products twice as cheap comparing to the state-owned enterprises. The experience of other countries shows that that's not acceptable. But unfortunately, we have not only state-owned monopolies, we have private monopolies. And the biggest problem is the monopoly in the energy sector. Although we still cannot remove it, although this very simple thing to do, having the proper political will and dedication. And again, making use of the experience of those whose countries are represented here and really demonstrated very impressive results. So maybe sometimes we tend to forget about it. We have monopoly in the banking sector. That's a very relevant issue. I just came from the parliament where we dismissed Ms. Hontareva, and now the new governor of the bank was appointed. But in the banking sector, the monopoly, including treasury, covers 70% concentration. Without the treasury, it's monopoly by 64%. So, in fact, only 25% of the banking sectors belong to private banks. Give me an example from Europe or from, well, I don't want to mention, of course, Northern Korea or Cuba. but 99% of the countries around the world do not have any monopolies in this sector. So that's not useful at all. So let's think together. We have here representatives of the public, experts from other countries, and let's develop for Ukraine the roadmap, which would be a good guide to move forward, to create competitive conditions which would allow for change in the situation for the better in the economy, and would let us and would give us an opportunity to be decently represented in the European Union, which we intend to join, I hope, within nearest 10 years. Let's be sure we can do it. Thank you. Dear colleagues, I apologize. I am Oleksandr Melnichenko, and I have another co-moderator who leads the key department at the Anti-Monopoly Committee of Ukraine. He's Daniel Fedorchuk. This department has always been the core of generation of not only new law but also new practice as well. Thank you for this introduction. Well, now we have we talk about matters related, which are difficult to overestimate. That's activities of AMCU and the Judiciary. We all know that the Judiciary has key role in the development of competitive environment. Like if you take Europe, that's the main driver of promotion to promote their competitive legislation. And although actually our Ukrainian courts have not had developed the appropriate case law in this area, still we already have some initial approaches to how the law on competition should be applied to create fair conditions for other players in the market. So I'm pleased to introduce to you Ms. Bulhakova, who is the Justice of the Supreme Court Cassation Chamber. Well, it's a very long name, yes. So the chamber, for intellectual property and protection of economic competition. The floor is yours. Good afternoon. Ні, ми не чуємо. No microphone. Okay. Once again, good afternoon. It's a big pleasure for me to take part in this event. Indeed, I represent the Commercial Cassation Court, which is now part of the Supreme Court. You know, recently we've implemented the judicial reform, so the new Supreme Court has become operational, including the Commercial Court of Cassation, and we have the chamber responsible for protection of intellectual property rights and the laws on competition. Unfortunately, we only have 3 justices now at our chamber. We have our assistants and secretaries and respective supporting services. Still, we hope that soon there will be second round of selection of justice to the Supreme Court, and our chamber probably will have more members, and our chamber is the smallest among others. So you know that by our legislation, the creation of this chamber is compulsory according to the current legislation, which means that the legislators do care about promotion of anti-monopoly legislation. That's why they decided the existence of this chamber is compulsory with the Supreme Court. So you know that now we have the new Code of Commercial Procedure. It's rather updated. code of procedure, and if any one of you has paid attention, it has some transitional provisions. According to these provisions, those cases that were submitted to the High Commercial Court of Ukraine and remained without consideration shall be considered on the basis of the new code. I want to say that we do not have many cases, maybe a couple of dozens of cases that we've considered. Out of them, 90% are the cases inherited from the High Commercial Courts of Ukraine. So those of you who have had a chance to read our judgments are not surprised with our new approaches. Still, we take into account the case law of previous courts that acted before 2017. We are often asked to provide some explanations to be issued by the plenary session of the Supreme Court. You remember we have this explanatory note number 15 concerning consideration of the cases related to the laws, the competition laws. So the question asked is whether other courts can refer to this explanatory notes. So I'd like to say that according to the new law, the plenary session stopped existing at the Cassation courts, and the only court having its plenum is the Supreme Court. So we can use this explanation issued by the plenary sessions of former High Commercial Court, but they have the character of just recommendations and can be used only as far as they do not contradict to the effective legislation of Ukraine. In our plan of our activities, we intend to analyze certain case law, develop our legal standards with regard to some categories of the cases, and then we would be able to issue this explanatory note for our plenary session. I need to say that those cases, they still reach the cassation level. Most of them are to challenge the decisions of AMCU concerning applications of fine to the business entities for violation of the laws on protection of economic competition, and this other category of cases is also linked with respective coordinated activities between different business entities. And of course, such entities always disagree with the decisions of AMCU or its regional branches and are trying to challenge these decisions through our Supreme Court. I want to say that in spite of the fact that the case law on such cases was not really well developed before, we still are trying to develop a single approach to this category of legal disputes in the light of the current legislation. Then, if you look at just these several dozens of cases that have been considered, there are some cases related to bid rigging or distortion of the results of the bids, where the business entities try to challenge decisions of AMCU. I'd like to say that today the Commercial Court of Cassation is trying to pay attention to each and every case dealing with the anti-monopoly legislation. If you take into account the caseload, we hope that will not last long. Still, we're trying to provide for deep analysis of every case to make sure whether the AMCU acted within its powers as provided by law and had sufficient grounds to apply sanctions against respective business entities. What else would I like to say? Basically, I'd like to stress once again that we are trying and we will keep on trying to develop our own case law with regard to this category of the legal disputes, and further on we'll try to issue some so-called generalizations or summaries of the case law to help the judges of lower instances and also to help business entities so that they can have better understanding of this legislation against monopolies and on protection of the competitions. If you have any questions, I'm ready to answer. Thank you, dear colleagues. I have a request for all the speakers. Let's ask questions later on when we finish the panel. Well, you see, Leonid and Valery have to go back to their offices, so if you have any questions, you can ask them right now, and then we'll continue with the questions after the session. Well, no questions, though. Then I have a question for Iryna. So, this famous explanatory note adopted by the High Commercial Court, it was in 2011. I'm not saying that the court should refer to it, but can judges use them in their professional activities as an opinion that deserves attention for purposes of adjudication in the appeal case? As I've said, yes, certainly you can use it as far as it does not contradict, does not counter the current legislation of Ukraine, but you know that the judge is supposed to deliver judgments on the basis of his or her convictions, being guided by the law. So actually, again, this is just a recommendation, this explanatory note, not something bigger. I will also abuse my moderator status to ask another question. My question is this. Ukraine now is in the process of harmonizations with the acquis communautaire, and some courts apply case law of European Court, and they probably do not see the difference between European Court on Human Rights and European Court of Justice, so they refer to judgments of the European Court of Justice. What would you say? Is that really admissible to use such judgments as the direct action provisions?
Thank you for this question. I do remember you during this court trial. Well, in fact, we do use the practice of the European Court, but taking into account that European Court isn't on the human relations, but we are speaking about the not the usual citizens and private people. The majority of the cases of the European Court are devoted to the personal people, especially as for the accessibility of the justice and so on, but we do not abuse it, we don't use it too much. As for the directions and regulations you've mentioned, we are not using them, at least for the verdicts which were taken in our court. We didn't have any regulation from the Luxembourg court. Thank you. There is the wish for Iryna Valerievna and for her colleagues not so many colleagues so far. It is understandable that today, because of your activities, though it may seem trivial, but it's obvious, I'd like to emphasize that the future of the development of competition policy depends on you, not only of the law, but of the competition policy of the state. So as you're looking at the cases connected with the strategic and social important markets, the importance of the impact of those verdicts for the Ukrainian markets and competition state will be decisive one. We do hope that this practice will be a progressive one and it will allow Ukraine to be very successful in the future. Please the greetings to your colleagues, to Mr. Selivanenko and others. Thank you.
А тепер, напевно, я перейду на англійську. Coming to the part of this session where our foreign colleagues will present their view on competition policy. And I will start with Mr. Kürşat Ünlüsoy. He is the Vice President of Turkish Competition Agency, Rekabet Kurumu. Please, the floor is yours.
Thank you very much, Mr. Chairman. I want to start my presentation by thanking Mr. Chairman Terentiev for inviting me alongside all these distinguished guests to speak on a very seminal issue, namely the triangle of, if you don't mind, I will go over some slides quickly. Maybe I will skip some of them due to time limit. Namely the triangle of competition law, judiciary development, and competitiveness. The context we are all in is unprecedented. When I was preparing my presentation at the weekend, I remembered how Kenneth Galbraith started his prominent work, Affluent Society. He writes that wealth can hinder understanding. Lack of wealth, then, is to be celebrated, since it could give a coherent agenda to pursue. His prologue seemed all the more pertinent considering today's debates on trade wars, protectionism, and economic nationalism. In such an environment, the job of developing countries who are trying to catch or surpass the earlier industrializers becomes undeniably more difficult. And in such an environment, we competition agencies need more innovative tools and schemes in order to maximize competition and gains from competition. Our agency has celebrated 20th anniversary last November, and our competition legislation is even older than the agency. It has been in force for 24 years now, and as you know, Turkey is an emerging economy, and competition regime becomes more important in such a dynamic economic environment. Before giving you a picture of Turkey's competition regime and judicial issues, I want to refer to The Path of the Law by Oliver Wendell Holmes. In his piece, Holmes touches upon the link between political economy and law, and he laments that the two disciplines were divorced. While disciplines may divorce or merge, economic life requires smart rules that have the least cost to society. Competition law is one such law, and the evolution competition regime in Turkey shows how deeply linked political economy and law are. Turkey, as a developing country, may lack a long history of markets and competition law by injecting competition as a principle into the constitution and empowering an independent regulatory agency. The state rendered competition and markets the main pillars of economic and social structure. Competition law has been adopted in 1994 and the agency became operational in 1997. The substantive rules are mostly identical with those of the EU. As you know, Articles 101, 102 of the TFEU and the merger regulation. But still, some aberrations exist. For example, no discrete clause exists on state-owned enterprises and state aid. State-owned enterprises are treated as any other economic undertaking. Such treatment is sourced from the presumption that, as Turkey is a mixed market economy with a history of state-led economic mind, the implementers of the law would be tendencies to be lenient towards SOEs, and that a separate clause would be perceived as an exemption. And also, the control of state aid is carried by a separate commission under the auspices of the Ministry of Economy. Here, if you don't mind, I should digress from the law and judiciary theme and talk on how TCA sees enforcement and advocacy as mutually reinforcing. As you will all appreciate, developing countries' legislation agenda and frequency of legislative amendments are dazzling. And we all know that suboptimal rules, once sedimented, are hard to reverse. Competition agencies, therefore, have a unique role in economic administration. The role of mitigating the collective action problem of the consumers. Also, we have the duty to eliminate, reverse, limit the harm done by government regulations and state interventions. We, in Simon Iryna's words, have to ensure that competition provides the foundation for legislation. Liberalization is also a process in which interest groups strive for lost privileges and competition values are priceless for a healthy liberalization. In this respect, we have launched various initiatives towards the government and private sector, as well as the consumers and citizens. We intensively give formal recommendations to the government in important strategic papers and legislative amendments, both primary and secondary laws and regulations. In the last 5 years, we have conducted a national survey where we reviewed all the extant laws and regulations in the country and filtered those that have a probability of restricting the competition more than necessary. And we have a separate department devoted to advocacy. Let me go over this is about the TCA's. It has administrative and financial autonomy, and it's independent in fulfilling its duties. I will come to the revenue part in the later slides. And it has some powers. These powers are very similar to those in the EU. The main, as we look at the organization chart, we have 5 supervision and enforcement departments, we can see, and each supervision and enforcement department is responsible to conduct examinations, inquiries, and investigations in certain sectors. The competition board is the decision-making body of the TCA. It has 7 members. The term of office is 6 years, and there are some qualifications for competition board members. Our staff number as of March right now is 369. 155 of them are case handlers. Our budget is this year's budget is about 20.5 million euros. And let me add a few more words on independence. I think it's important. Similar to the rest of Europe, the independent regulatory agencies in Turkey have mainly been a result of liberalization of formerly state-run industries. The first IRAs to be established in Turkey have been the Capital Market Board and Turkish Competition Authority in the 1990s. In the period of 2000 to 2002, IRAs in telecommunications, banking, energy, public procurement were established. It is widely acknowledged, the EU, IMF, and the World Bank have been very influential in the design of the regulatory regime in Turkey. These IRAs, similar to most countries, have wide discretionary powers despite their being non-elected. Still, the unitary structure of the Constitution renders independent agencies affiliated to a ministry so that the administration remains indivisible. So, no IRA can be singled out as non-independent despite its status as an IRA, as all IRA statute renders them independent in terms of all criteria, as I said before. Competition agencies are recognized for the need and ease of achieving independence. They need independence because they cover all industries. Their task is less specific than sector regulators, and they have to lobby in favor of consumers or citizens who suffer from collective action problems. Their achievement of independence is rather easy because their task is too broad and diverse to attract capture efforts from the regulators. The politicians welcome advocacy and other policy efforts from the agency that could increase national competitiveness and welfare. And the TCA is an independent body in the sense that there's no unfair dismissal without good cause, of course, in the history of the agency, and both budgetary and organizational autonomy are immaculate, we can say. The agency has great potential not only to draft its own laws, but also to be influential in the related sectoral laws as well as national legislative repertoire. And as I stated before, 2 years ago, the agency has reviewed all extant legislation in the country to filter out those with a potential to unduly restrict competition. It's also believed that capture of the competition agency doesn't seem to be likely given very infrequent ad hoc contacts. Also, in addition to this, diversity of the members or commissioners is also satisfied as public, private, and academic sectors are all represented in the board. You can see in the slide the number of cases. As we see from the slide, the number of cases is decreasing by the time. It can be attributed to most of the merger cases. Also the competition advocacy efforts. These are the important cases in Turkey in the last decade. Maybe I can mention the decision about the banks in 2013. The fine the board issued 1.1 billion Turkish liras which is approximately 267 million euros to 11 banks. Last year, the total fine was almost 200 million Turkish liras, which is approximately to 50 million euros. It's the fines related to the substance, the imported fines. According to the Article 55 of the Competition Act, suits shall be filed against administrative sanctions before the competent administrative courts. The competent administrative courts refer to the first instance courts in Ankara, and the judgment of first instance courts can be further appealed to district administrative courts, which is the last resort court as a rule, but in certain circumstances, Court of State serves as the last resort. When we look at the slide and the chart table, we can see that the ratio for unfavorable judgments of the TCA's decisions is low across years. And we can say that the annulments are mostly due to formalistic reasons. In other words, annulments on substantial grounds are rare. Yes, what's it's about the development of the legislation in Turkey. I will explain very briefly. We had 2003 amendments. One of the according to these amendments, the powers during the on-spot examination were clarified, and also it became available to publish recent decisions of the Competition Board in the official Gazette without awaiting the jurisdictional finalization. The registering 25% of fines imposed by the Competition Board as revenue to the authority budgets was ended. And also it became available that appealing against decisions of the board would not cease the implementation of decisions and the follow-up and the collection of fines. Do I have time? Okay. And the 2004 amendments, the revenues is important here, payments to be made by, we have a special separate revenue from the general budget, so it's like an automatic revenue. It's very important for especially for the independence. The revenues come from the increased portion of the capital increase of the firms, or when you establish a firm, limited firm, or incorporated company, the capital, the 4 per 10,000 of the capital comes to the authority. Yep. There are the other amendments. I will go quickly, especially the participation of competition board members in the inspection committees was ended by a court decision. So we changed the law. Other amendments we have, and I will skip these slides. The Appeal Competition Board decisions filed before competent administrative courts as first instance. Before the amendment, the court of first instance was the court of state. The we also need an expertise on, about this issue. I will go quickly. The others major developments in secondary legislations is very similar to, the leniency guidelines, fines and leniency regulations, and the other amendments on merger communique. Yes, this is important. We can say that those who investigate should not take part in decision making. Okay, I'm coming. We have a draft amendment Competition Act, and the last slide. I'm going to last slides. Yeah, as you see, Turkey, along with all developing countries, is trying to perfect both its written law and practice. Our independence and powers are only the tip of the iceberg. Without effective use of these independence and powers, we cannot increase competitiveness, contribute to growth and development, and improve the standard of rule of law in the country and beyond. In the line with the emphasis as we see in the articles of Professor Kozachenko, the TCA's main target is to be effective rather than to be satisfied with independence and mere enforcement. Let us conclude by presentation with optimism and hope that our quest for perfection will be an effective one. Thank you for your patience.
Thank you, Mr. Ünlüsoy. Actually, we just discussed that Turkish experience is of a particular interest for Ukraine because many view European competition acquis and US antitrust law as being too advanced for Ukraine to achieve easily, while development of Turkish competition agency and competition policies is rather comparable to what we have in Ukraine. Unfortunately, of course, the time restraints probably didn't let you say what you wanted to say in full, but we note that all the presentations will be posted online and will be made public. Now I'm very pleased to turn to experience of our another neighbor and introduce Mr. Cosmin Belacurencu. He's the member of board of the Competition Council Romania. He will speak on competition issues in pharmaceutical markets. Please, floor is yours.
Good afternoon or good evening. First of all, I would like to thank to the representatives of Ukrainian Competition Authority for inviting us to attend to this conference. We are three persons, representatives of Romanian Competition Council who attends to this conference. Mrs. Vice President Kleininger, one of our colleagues from the External Relation Department, and me. I also want to thank to the organization team for the efforts they have made to prepare this event. I will start my presentation with an informal introduction. As many of you have already noticed, I have Ukrainian roots. My grandfather was born near Izmail, and after the Second World War he decided to follow the love of his life, my grandmother, and they settled in a small village in Romania in the Danube Delta near the border with Ukraine. Unfortunately, I don't speak Ukrainian. I think the main reason is because my mother is 100% Romanian, and in our family we have spoken only Romania. But being a child, I remember some conversation between my father and my grandfather, and I remember some expression like "Șote robeș," yeah. And also I remember I like to watch at Ukrainian TV station, for which my grandfather had a special TV antenna. I like to watch "Nu zais, nu pagadi" cartoons. Yeah, it was the yeah. And now I will switch to the serious part of my presentation. I want to present you very briefly the Romanian Competition Council main activities regarding the pharmaceutical sector. In 2009, we opened 4 investigations and we finalized them in 2011. During the investigation, we found out that 4 medicine producers, Belupa from Croatia, Baxter AG from Switzerland, Bayer Romania, which is a subsidiary of Bayer AG Germany, and Sintopharm, a Romanian producer, had in their distribution contracts concluded with the Romanian distributors, they had export ban clauses. So we found that this is an infringement of Article 5 of Romanian competition law and also Article 101 of European Treaty. So we find the undertakings with a total amount of 13.5 million euro. Our decisions, the Romanian Competition Council decision, were challenged by the undertakings in the courts, and the courts confirm our decision. Let me explain you a little bit about the prices of the medicine products in Romania. The prices are regular. I mean, the prices of the prescribed medicine in Romania, those prices are regulated by the state, and the prices is the lowest price of the same pharmaceutical product within the 12 countries in European Union. That means the Romanian prices for medicine are lower than the majority prices of the same medicine in the European Union. And this is an opportunity for the distributors from Romania to export medicine in other member states, countries where the prices are higher. In the last 2 or 3 years, our approach regarding this issue has changed a little bit. 2 years ago, I think, Romanian Competition Council issued a point of view to the Romanian government saying that if Romania face a big crisis of medicine, the state is allowed for a very limited period of time to limit it, to impose an export ban to the pharmaceutical distributors, but only for a limited period of time. In 2017, we finalized a sector inquiry on pharmaceutical market. During this investigation, we analyzed 36 relevant markets defined at ATC 4 level. Also, we analyze distribution systems, marketing and promotion activities, or direct to pharmacy distribution model. I want to present you the main conclusion. One of the conclusions is that generic medicine have low market share, although they are at least 35% cheaper than the innovative medicines, and they have entered the market for many years. Although the prescription of medicine is made on an active substance, 57 of the patients require a given commercial name when they go to the pharmacy as a result of a doctor recommendation. And in our opinion, the main cause is the intensive promotion made by the innovative medicine producers. They sponsor, they pay the participation of the doctor to many international congresses or seminars, and in our opinion, this is not very fair. We also find that 9% of the turnover of the innovative medicine manufacturers is dedicated to promotion, and in the case of the generic producers, they allocate only 5% of the turnover. Another conclusion is that the cheapest generic medicine is missing from the market, or is it sold in small quantities, and the main reason for that is the low distribution margin for cheap medicine. That means for a pharmacy, the distribution fee for selling medicine is a percent applied to the price of the medicine. That means if a pharmacy is interested to sell more expensive medicines because they make more money after selling those kind of medicine instead of selling cheaper medicines. Another conclusion is that the majority of the distributors condition the delivery of highly demanded medicine, which are sold very well, by the purchase of other medicines that the pharmacies do not want to acquire. This has happened, a pharmacy, usually the independent pharmacy, they go to the distributor and ask for high demandly medicines, but the distributors offer them, okay, we supply you what you request, but in the same time you have to buy other medicine that are not sold very well. We issue at the end of this sectorial inquiry, we issue some recommendation to the Romanian government and also to the Romanian other public authorities. One of the recommendation is that limiting the marketing cost of medicine producers for certain categories of activities. A better definition of the expenses that can be recorded for each type of marketing or promotion activity. Another recommendation is that the doctor could be encouraged to prescribe generic medicine by providing financial incentives if they fit into a monthly set budget. And the saving exceeding that budget could be used by doctors for other purposes like a training session or attending to international congresses. The sale of cheap medicine by distributors or pharmacies could become profitable by applying a fixed amount to the distribution service or pharmacy. So we suggest that to apply the same a fixed amount of money for each kind of medicine the pharmacies sell. That means it doesn't matter the price of the medicine, the pharmacy distribution fee is the same, and we try to persuade, to convince pharmacies to recommend to the patients cheaper medicines. The introduction into the health law of a provision banning tied sale in the form of packages regarding the distribution of medicine. Another recommendation is that the price of both the generic medicine and also the innovative one, which the last one being out of the patent, should be at the same level. And the last recommendation is to improve the availability of medicines. The competition authority recommends that distributors should supply all the pharmacies, not just the integrated one. I don't know how is in Ukraine, but in Romania, the main 6 distributors of pharmaceutical products in Romania, they have their own pharmaceutical chain. So usually they supply their own chain, but they don't supply to the independent pharmacies. We also analyzed the DTP. This is the direct-to-pharmacy distribution model. What does it mean? So there are some producers of medicine which prefer not to use the traditional distribution system with the many distributors. They choose one distributor and they distribute the medicine through that particular distributor. We know that this system is applicable in UK and also in Netherlands, and we found some positive aspects regarding this DTP and also some negative one. So for positive aspects is the better service, better availability of the medicine to the patients, reduced waiting time for the patient, and transmitting to the patient a part of the benefits in court. The negatives one are the total limitation of export, internalization of the benefits, and worse commercial terms. This is my last slide. In 2007, we opened 2 investigations regarding a possible abuse of dominance according to Article 6 of Romanian competition law, and also which is the equivalent of Article 102 of the European Treaty. we opened this investigation against Roche Romania, which is a subsidiary of Roche. And one investigation we suspect a margin squeeze, and the other one the exclusion from the market of a generic producer. So that was my presentation. Дякую.
Thank you very much indeed, Mr. Belacurencu. Actually, the issues which you raised during your presentation are not foreign to Ukraine. In particular, interplay between generics and heavily promoted innovative medicines has been the issue of one of major cases which been resolved recently by the Anti-Monopoly Committee and which now goes to the courts for review. The courts means it goes into the realm of legal department, which I run. So I personally was very much interested in listening to you. Thank you very much. And now I am pleased to introduce Mr. Mikhail Mikulík. He is the head of Appellate Session Office for the Protection of Competition of the Czech Republic. Please, the floor is yours.
So thank you very much for introduction. And thank you in particular to Yuri for having an opportunity to participate at this competition law event, which is actually not my first one. My first experience here, I was here 2 years ago, and I talked here about relationships between national competition authorities and international bodies like EC and ICN. So, I will focus in my presentation on not public enforcement of competition law. Everyone here was spoke here about private enforcement of competition law. I will rather draw your attention to the second lack of competition law enforcement, and which is called private enforcement of competition law. Why? The reason is quite simple, because European Council adopted a directive relating to this issue, and all EU member states were obliged by the end of 2016 implement this directive into their legal systems, into their laws. So, on the first slide, I just listed some, let's say, landmark judgments issued by now Tribunal and European Court of Justice relating to private enforcement of competition law. We haven't got enough time to go more into detail, but you can definitely find them on websites of this court if you are interested in and go through them. They are not long. Mostly they are just preliminary ruling. On the bottom of the first slide, you can see some, let's call it legislation attempts by some European institutions relating to private enforcement of competition law. This green paper, white paper, and actually these attempts ended up by adopting this directive. We adopted this directive, actually here you can see main objectives of the directive, to ensure the full effect of Articles 101 and 102 of the Treaty on the Functioning of European Union, which means 101 article governs forbidden agreements, 102 abuse of a dominant position, and the proper functioning of the internal market for undertakings and consumers, approximation of relevant legal institutes, which are mostly based in civil courts and civil procedure courts in EU member states, so that victims of anti-competitive conduct in particular and consumers may effectively seek damages. Optimizing the interrelation between public and private enforcement of competition law to ensure equality of legal arms of victims across EU member states and increase of legal certainty. Now let's move to the act on damages. As I said, last year our parliament adopted an act of competition law damages, and by this act that directive was implemented into our legal system. And now I will go just very briefly through, at least from my point of view, the most important legal institutes included in this act and included at the same time in that European directive. But some of them are just in the act. They were introduced newly to the Czech legal system. They are not included in the directive. I will touch this point later on. So, right for damages, anyone can claim damages. What actually these damages consist. So, actual loss of profits, plus interest, nothing new. A joint and several liability of infringers against, I guess this is nothing new in private civil courts across all EU member states. However, the directive introduced some exceptions to this rule, and these exceptions must have been implemented into laws of EU member states. So, in some ways, this joint and several liability is limited, and this limitation concerns those who were immunized, fully immunized, under a leniency program. However, it doesn't apply if this exception doesn't apply if full compensation, full redress is not possible achieved from other infringers. Let's say from other members of cartelization. And the second exception accounts for small or medium-sized enterprises with their market shares below 5%. So those who breach competition law, and they can be regarded as a small and medium-priced enterprises, and moreover, their market shares doesn't reach a 5% threshold. They doesn't have to pay damages to those who can't be called as direct or indirect purchasers. Yes, the same apply for those who are immunized under a leniency program. Yeah, and against this exception doesn't apply if they enjoyed a leading role in a cartel, or they coerced other members of a cartel, or in case of recidivism. However, this directive doesn't speak whether, when we are talking about recidivism, whether it should relate to the same nature of a breach of competition law. So whether it should be always forbidden agreement or abuse of a dominant position. From my personal point of view, it doesn't matter whether forbidden agreement or abuse of a dominant position, and because I think it follows from the directive as a whole, and the fact that directive relates to these both practices. Rebuttable presumption of damages in case of horizontal by-object agreements. This is of immense importance. So what does it mean? It means that in case of cartels, let's say hardcore cartels, so price fixing between competitors, market sharing of consumers, or limitation of outputs. In given case, if you claim damages, you don't have to prove the existence of damages. The only thing you should prove is, not the only thing, but the only in relation to damages. Once you prove there is breach of competition law, then you don't have to prove existence, but the amount of damages and causal nexus. 5-year subjective limitation period. Against this period start running from the cessation of violation of competition law, and it's applicable under 3 conditions. All of them must be fulfilled at the same time. So you should have knowledge, or at least reasonable expectation of knowledge of who is an infringer, of an infringement, and damages. And there are some exceptions when actually this limitation period is suspended or interrupted. So let's say during administrative investigation pursued by competition law authorities. However, once this investigation is over, this limitation period can't end at the earliest than 1 year after this investigation, so that everyone enjoys chance to sue for damages. There is no objective limitation period. I don't think this fact is in conformity with legal certainty. What does it mean? It means that if you look at civil cause, mostly all kinds of damages are subject to subjective and objective limitation periods, and these objective limitation periods mostly they are longer, and subjective limitation periods should run inside, within the objective limitation periods. But in given case, it means if you haven't got either knowledge of an infringer, or the damages, you learn it after 20 years, once the infringement was ceased to exist, you can sue for damages. Passing on of overcharges and defenses, actually compensation for actual loss at any level of the supply chain shouldn't exceed the overcharge harm suffered at this level. So the directive tries to avoid overcompensation. Courts may estimate a share of any overcharge passed on down the supply chain, and at the same time they may assess the amount of damages, because in many cases it will be nearly impossible to calculate the precise amount of damages. So they enjoy, the courts, the judges enjoy the right not only estimate the amount of damages, but also to estimate the share of any overcharge passed on down the supply chain. And defendant can invoke passing on defense, but however the burden of proving rests with him. This we may skip. And I talked about court's discretion to estimate the amount of damages. Disclosure of evidence. This is of immense importance, especially for competition authorities and for the European Commission. What does it mean? It means that those who claim damages, they are in weaker position, in weaker procedural position. They've got no access to evidence to draft their claims and so on. So just to balance this, they should have access, let's say privileged access to some kinds of evidence relating to their claims. And a court may order a defendant or a third party to disclose relevant evidence which lies in their control. It must be proportioned, and I will touch this point later on, because the directive speaks just about disclosure and some conditions for this disclosure and so on. However, into our legal system, by a new act was introduced a completely new discovery procedure, which is common rather for countries with common law background, not for countries like we, Germany, and so on. A lot of evidence relating to private suits can be found out in files of national competition authorities. And the evidence which is in these files is actually split into 3 groups. On blacklist is evidence which never ever can be disclosed to anyone. So now I'm talking about leniency statements and settlement submissions. This kind of evidence can be, according to our act, inspected solely by a judge. The judge can't make any copies of this evidence. No representative of undertaking can have access to this evidence, and so it's forbidden, as I said, to show off this evidence and to use this evidence as a evidence in a civil court in civil suits. On the grey list are withdrawn settlement submissions and information prepared either by NCAs, for example, information requests sent to undertakings, or those information prepared by undertakings or third parties within an administrative procedure. So this evidence can be disclosed once the administrative procedure is over. The reason is simple, just it's very important not to threat the success of this administrative procedure. And on a white list is the rest of this evidence. It can be disclosed at any time. We are talking about pre-existing information. Just to put one example, if you go to a down rate and you find in their computers some emails, and you can from these emails you can find there is actually these emails can as a whole can form a forbidden agreement because these emails existed before an administrative procedure, you can use this even within the time the administrative procedure is still running. Consensual dispute resolution, we just skip it, it's not as important for you. Effect of national decisions, I think it is important. So final decisions on the infringement issued by a domestic competition authority or European Commission is binding for domestic courts in terms of its declaration that someone breached competition law, so the court must take it. When we are talking about final decision on infringement issued by other competition agencies, the directive speaks that it should be regarded as a so-called prima facie evidence for courts in other EU member states. We've got it, we use this according to our act as a rebuttable presumption. There was a breach of competition law. Discovery procedure, I mentioned. I said that this is a new legal institute introduced to our legal system, and I just put there some main points relating to this. An injured party may bring a motion to discover documents before a court prior to commencing a lawsuit for damages. Parties to the procedures are injured party, infringer, and anyone having under its control documents or other tools necessary for ascertaining the facts. The person seeking damages and the person seeking discovery of documents should send to the court financial security. The minimum is 100,000 Czech crowns, which is roughly $5,000 US for prospective damages resulting from access to documents. The upper threshold is not provided, so it can be even in millions. And if damages occurred from this discovery procedure, then this financial security should be used for these damages. And documents may include confidential information protected by law. In such a scenario, a court may assign an impartial person with necessary qualification to make a detailed summary of documents. In case that someone violates a court's order to discover documents, he can pay a penalty up to 10 million Czech crowns. If in a given case it refuses to disclose documents, an undertaking who breach competition law, it may pay fine up to 1% of the net total turnover, and moreover the facts that should be actually proved by this evidence are deemed to be proved. This is not rebuttable presumption, it's fiction, it can't be rebutted. So, conclusion, Act on Damages introduces to the Czech legal system pro-litigation provisions, let's say discovery proceeding. Act on Damages concerns solely to damages caused by undertakings and not by public bodies. According to our Competition Act, competition law can be breached not only by undertakings but by public bodies in some cases as well. And Act on Damages doesn't concern other rights that may derive from a breach of competition rules, like claims on unjust enrichment, nullity of forbidden agreements, or refraining from illegal contact. Act on Damages, which is of immense importance, doesn't introduce neither collective nor representative actions, and as I said, there is no limitation period in competition law damages. Thank you for your attention.
Thank you very much, Mr. Mikulík, for this presentation. Actually, this topic, private damages claims, is going to be very hot for Ukraine too, because except one provision in the law, we have not yet had a developed law on this regard, let alone court practice. But this is our very nearest future. So that was of high interest for us. Thank you very much.
Шановні колеги, виходить наш цей
We are about to finish this part of our forum, similarly to the last year when here the panelists were Mr. Zheny, Kozakov, Lvov, Igor Bendisuk, and the concluding remarks will be offered to Oleksandr Nagorny. I would just like to request that all this information will be placed at the relevant website of our foundation. Please try to be very concise. Well, good evening. I will certainly be more concise in comparison with the last year. Is my understanding correct? So, dear colleagues, indeed that's the last presentation, but I think it's a very difficult subject matter. That's the adversarial approach to any investigations related to violations of the laws on competition. So I'm trying to talk about this adversariality at all stages of proceeding. Why? After 25 years of activities of AMCU, which both I and Alexander and I used to be involved, so probably here we need to check two issues. First, how efficient is the system? Well, I think all understand the basics. I mean, the extent of efficiency of a system is the answer to the question to what extent such organization can be free from outer political influence, and second, to what extent the internal mechanisms of the organization ensure professional, independent, and impartial evaluation of the specific situation. Looks like a very simple thing, but probably the things are not that simple. I remember there were times when Alexander and I were lucky to take part in celebration of 100th anniversary of the birthday of former Chancellor of Germany, Erhard, and I then found a quotation. He used to say, he stated that he needed an anti-cartel agency to protect myself from myself. He stated that the government is actually re-elected once every 4 years and often is tempted to look with blind eye at the violations of the competition to gain more support. So such agencies should be able to really resist any conflict even with the government. I don't want to remind you about the last year, the previous year. We have become witnesses of some events of this kind. So it looks like from the external point of view everything is fine.
But let us look at the situation, what should be inside or can be inside. The main aim of the activities of the committee is the efficiency of the markets. And here we're thinking about the depth of the interference, both knowing the external and internal spheres and the depth of the interference. Sometimes the agency does not interfere enough into the relationship, and then the market processes do not allow to turn on the mechanisms of self-regulation of the market, or there can be the vice versa, an opposite situation when the agency is interfering too much and it ruins the freedom and the mechanisms of the self-regulation. It increases the uncertainty of law between the different types of behavior. So this is already the limitation of freedoms and rights. I think that this issue for today is really relevant. I know that it has been relevant during the period when I was working at the committee, because all the time this issue was really up to date. Why did I show this picture in the end of this slide? Because the first head of the Anti-Monopoly Committee was always saying, guys, don't be the elephants in the dish shop. You don't need to ruin, with the help of our law, the business which is just emerging, which is given birth. So I remembered those words. Well, of course, he repeated this phrase from time to time, that's why I remember it. But this is in spite of how long did we live with this institution? For 25 years or 5 years? This is the test we need to check every day. All the time you need to understand that this authority, with such huge authorities and rights, can either harm, as the committee has the slogan, the competition brings to flourishing, or it can limit and restrict rights and freedoms. So we, as the former colleagues, and it's very pleasant for me to see the colleagues here with whom I used to work in this audience, and I do know that we have the same slogan, that there can't be an anti-monopoly employee who is the former one, because we always go on working in the same sphere, and we are always thinking about this sphere with all our soul, how it's being developed. So even working in the law business, we totally like this sphere, it's close for us. So through the civil society institutions, we were trying to influence, or at least to suggest some ideas which could be implemented at the modern society. So, the Civil Council, attached to the Anti-Monopoly Committee, which is existing for about 6 or 8 years, this Civil Council at the Anti-Monopoly Committee, we used to suggest, well, I name some of the initiatives I took part in, because this is the stage where we are forming the huge propositions and suggestions for the committee. So I will name 4 of them. The provision of the independence and professionalism of the members of the committee, including with the help of the way of the constitutional procedure of the appointing all of the members of AMCU. Well, it seems to be favorable, the committee is functioning, but the procedure of the appointing is really significant, including the words I began with, because of the rule of law. Because the procedure of the appointing influences the independence of the whole authority and each separate member of the committee who is a decision maker. It's very important, you shouldn't underestimate it, and we think this procedure needs to be provided and written down. The implementation of the legislation level, the mechanism of the rotation of the members of AMCU. Well, of course, this rotation used to exist. We implemented it in the 2000s, in the beginning of the 2000 years, when this rotation existed, when each member of the committee was substituted, or maybe 2 of them were replaced every year. So they had to be replaced annually. And it provided the principle of avoidance of very harsh approaches and amendments to the approaches. So it always takes into account the elections into Verkhovna Rada, the parliament, and the president, because the parliament can be changed, the president can be changed. So 10 members of the committee, or another number, can be replaced too, one by one. and they will work and be appointed by different parliaments and presidents. This is incredibly important for the independence of the committee. Another institution of the civil society we are cooperating with is the Ukrainian Federation of the Safety, which is connected with the insurance business. Oleksandr Zavara was present here, and he spoke about the level of competition in the insurance sphere. So, working in the insurance sphere, we've suggested an idea which is relevant now, is the creation of the system of the independent assessment of the quality of the work of the independent members. Ms. Lapina has already mentioned that this problem is risen at the state level, and it's nice because we are having this idea not for the first year already, because there should be the system of the open dossiers. The society must know how the members of the independent authorities are behaving. We need to follow their behavior and to know who is appointed into the independent authorities, because the members of those independent authorities need to be separate from the politics. Those are separate regulators who are playing a very significant role today. The same system is suggested to be disseminated into the activities of the Anti-Monopoly Committee. The next powerful structure is the Association of the Lawmakers of Ukraine, with which we cooperate closely too. We suggest lots of things and legislation initiatives. By the way, those legislation initiatives, thanks to the MPs, are formulated into the law drafts. And they already can be found in the first readings, some of them at least. The approximation of the procedure of the law cases according to the standards. Well, there are lots of points. I chose only two of them. Is to separate the authorities of the investigation from the decision-making process. This is the blue dream of mine. And the regulation of the terms of the case trial. I will come back to that. But before that, I'll mention that we just heard the speech of Mr. Mikulík, who told us about the directive of the Europarlament 104 of 2014. Last year I was saying that it's very necessary for Ukraine, because we got used that in the agreement association we have certain directives we need to be compatible with in our legislation. And our committee almost performed all of that. We just have only some work to do left. But during the times of the creation of the association agreement, when it was signed, some time has passed. Europe went on, but we still have the same list of directives, which are rather relevant but not new. They can be obsolete. New directives emerge, for instance this one. And this directive of the Europarlament is designed for, I must say, the simplification of the access towards the justice. For me, as a citizen, I don't want to go to the committee. I want to go to the court and to prove my rights. I want to get some proofs from the Anti-Monopoly Committee and from the enterprise which violates my rights or any other enterprise. So this is the free and direct access to the court. This is the demonopolization of the Anti-Monopoly Committee itself. I think that in the rule of law society it should be implemented. For now it's not implemented in Ukraine, and so far we are not close to it. Europe has done it already. I've checked just recently, only 4 countries in the European Union have never adopted this directive. All the rest have already done that. I will remind you, last year only 7 countries of the European Union adjusted that. So the Europe is moving very fast. The question of the collective court files is really relevant, and it's totally not implemented by any law. We can't find the system of the collective suits or lawsuits. We can't fight the monopolists on our own. We can only apply for the Anti-Monopoly Committee. And the committee has a rather big burden of work. So this law draft, which was adopted in the first reading, and the law of MP Ivanchuk, the law draft, they tell us about the prioritization of the court files. Not a single application of ours will be considered by the Anti-Monopoly Committee. Only the priority ones will be considered. That is why the access to the justice, the direct access, is really necessary. So I plead the civil society to think about this initiative and to be involved in it. And finally, about the model. The models, which are existing ones already, for now we have the committee which is acting according to the unified administrative model. Those are investigations and decision-making process is taken in one competitive agency. Competition agency. We know different examples. For instance, the example of the United States, the Department of Justice, where they have a competitive court model. We know the competitive model, well, not the court one, but competitive one in Canada and other countries. We know the examples of the unified administrative model. For instance, the Federal Trade Commission of the United States, the European Union, the Germany, France, and other countries, lots of countries. But the model itself is nice, but you can always find lots of devils in details. So I will name, in short, the example of the European Union. In 1981, European Commission recognized that the investigation order and the adoption of the different decisions of European Commissions isn't corresponded to the standards mentioned in the Article 6 of the European Convention of Human Rights. To correct this situation, they had certain measures implemented. But why wasn't it correspondent? First of all, because it was not correspondent to the requirements of the independence of the administrative process in the understanding of the Convention. And secondly, and nota bene please, this is a very important conclusion of the European Commission, that the simultaneous performance by the Commission of the functions of the investigator, the prosecutor and the judge on the objective reasons, not subjective but objective reasons, leads to the blaming direction of the Commission during the investigation and the verdict in the case. So the way is comprehensible. So just to correct this drawback, the Commission implemented the Institute of the Independent Hearings. What else was taken into consideration? That when the person is taking part in the court trial, this right to complaint still does not compensate the drawbacks of the law procedure and investigation procedure. Not a single court, whether it's fair or not, it cannot take... Well, it has to take the decision, it has to take a verdict, but it can't, because the investigation was led in this way, so it can't take the verdict which would be correspondent to the highest requirements which are foreseen by the Convention of Human Rights. And the volume of the authorities of the court cannot fairly and fully renew the rights. As I already mentioned, the Commission adopted the decision about the person from the court trial and hearings. This person had the guarantees of the independence, and this person had to make public all of the reports as for the consequences of the hearings held. In the law draft 6746, which is adopted by Verkhovna Rada in the first reading, this institution is being offered, it's suggested. The hearings, this is Article 46.2, hearings as for the violation of the legislation about the protection of economic competition. Now we are aware that there is the great oppression and the lack of perception by the MPs who got acquainted with this project and law draft, so the chances for this article are so far not substantial at all. Still, we shouldn't stop our work. The suggestions, which are now the conclusions of what I mentioned above, in our opinion, even under the existing system, even without any amendments to the legislation, to provide those principles in the European Conventions on Human Rights, we assume that it's possible through the implementation in the Anti-Monopoly Committee of Ukraine of the new roles. I mean, for each case to have its own state representative who investigates the case. Each case must have the representative who will perform the monitoring and overview, and the person who is responsible for the hearings. Still, those authorized people and those positions will increase the involvement of those people at the early stages. We do hope that it will create and rise the ability of the Anti-Monopoly Committee at the higher level and the competitiveness in the proofs and evidence. Well, maybe there are lots of other different options, but I must say that in fact, the first 2 points of this suggestion, I mean authorized people who investigate the case and the authorized people who conducts the overall overview, they already existed in the third staff of the Commission, because we always had the curator of the certain department who deals with the markets, and we always had an authorized person who investigates the case. And those 2 authorized agents were always having contradictions, sometimes find compromises, and the sides were, at some stages, could be even involved in such discussions. So, in fact, the authority itself had the huge competition of proofs and evidence. The next point, and the last one, is the regulation of the terms of the cases. Well, you can find the correspondent article in the law draft. I mean the law draft number 6746, which was adopted in the first reading. So there are suggestions of different terms, 3 years, 5 years, or half a year, depending on the category of the case. In our opinion, this is a possible option, but it's not the best one, because in the European Union they don't have the terms of the consideration of the case or the trial. So, this trial term should just provide efficiency. That is why we created this cutout of the situation which exists now. You can see that to the left there is an anti-monopoly committee, and this is a child which has been born, a baby. Then in the center you have a boy who is already sitting at the desk but still in the kindergarten. This is the time when, since the birth till now, we have a decision as for the beginning of the trial, and then the court. This term lasts for 1 or 3 years. So since the final decision, children who have been born in the beginning are already going to school. But it is not bad in the situation when everything is adopted in a proper way, in an appropriate way, and had the court expertise. But just imagine when the court expertise was not appropriate. Those relationships, which used to be 7 years ago, they were not properly assessed by the body and authority. And we need to calculate the expenses for the business and for the state because of those verdicts. So, in fact, there are certain risks. In spite of not so many verdicts of anti-monopoly committee are being cancelled, but still we have certain risks. So this is the point of the making those terms of their investigation or trial shorter. I wouldn't say that this is rather informal. It's formal and not a bad situation. We tried to go beyond this square or triangle, whatever you say. Or like Münchhausen took himself from the hair and took him out of the dump, we decided to presume how we could make this process more efficient. One of the ideas, we suggest the following. Maybe it's necessary for the standard decisions, which are already formed according to the court precedents, the committee should adopt on its own. So when we have the court precedents, it would speed up the process and it will decrease the discussions in the committee itself. But the decisions which are totally new, where the committee is trying to test the new sphere, to test new norms of law, maybe even we need to foresee that this trial shouldn't even begin, like it's happening in the European Union. The case is not open when we have the formal decision about the opening of the case. Maybe the institution should gather the evidence and then, with this evidence, to go to the court and to create the precedent. Then maybe we won't have those consequences I showed you before, that the child is already going to school and we are still thinking whether this verdict was lawful, whether it was not. This is a certain idea. Not to have the subject under the conditions that the case is already open and for the 7 years he has to prove that he didn't violate anything. So my last slide is here. Maybe. I'm not sure. So we are speaking, well, unfortunately we don't have judges here, but still, we are speaking about the creation of the specialized court, competition court. In our opinion, we can't create this court now if we don't localize in the Anti-Monopoly Committee all of the decisions. So the Anti-Monopoly Committee must have all of the decisions through the central staff, and the territorial department should create the whole system when all of the verdicts and decisions are complained about only by the Anti-Monopoly Committee. Then it will be interested for the territorial department to take the lawful decisions, which would be predictable, and thus we would localize. We will not allow those solutions to be complained all over Ukraine. Then we will be able to create the competition court, which will deal only with the solutions which have been already tested by the Anti-Monopoly Committee and the central staff. This is one of the preconditions of the possible creation of such kind of court. And the last one. Somehow I liked this drawing. I decided to put it into one of my slides, and I wrote that we need the competition procedural code. Last year I was thinking whether it exists for the committee or for the court, but every day I am being persuaded that such competition procedural code should be the unified both for the anti-monopoly process, I mean the process which is performed by the Anti-Monopoly Committee, and for the court. Well, of course, we lack such practice, but I can assume that this code would allow rather efficient process of the investigations of not only of Anti-Monopoly Committee, but of the courts too, and to increase the efficiency, because in fact the risks and the pressure to the society if the Anti-Monopoly Committee is mistaken is rather high. That is why this sphere deserves for a separate code, which would be a procedural one. That's it from me. Thank you. I'm sorry that I was a bit too emotional. Thank you for all of the participants of this session for rather interesting presentations. It was really concerning the relevant topics or even today's topics of the agenda. Taking into account that we are out of schedule, I think that you should ask the questions if you have any personally. So thank you for the participants now. Esteemed participants of the forum, we are over with this panel discussion, and I thank all of the participants for such a productive work, and the people who already left us. After listening to Oleksandr Mikhailovich, I again understood that we are the big anti-monopoly romanticists. He showed us his dissertation now, his thesis now. Well, we hope that he will be able to implement that at least in the thesis, at least in theory. I'm really sure that he will be able to implement that. In the end, I'd like to conclude with several of my thoughts, as I won't have an opportunity to sum it up in the end of the whole forum. First of all, I'd like to say that we should thank the Foundation of Development of Competition, Mr. Hasan Kakayar, and the little administrative team who've conducted such a huge piece of work. And this thesis about the inclusive competition policy, so its ideologist was Mr. Sivkac, and it is, to some extent, an anti-monopoly romanticism too, because the inclusive competition policy will exist in Ukraine when this forum begins with the speeches of the President of Ukraine, the head of the Parliament of Ukraine, the Prime Minister of Ukraine, and they will be competitive in this hall to make a speech and to let us know what they think about the competition policy in Ukraine. So of course I wish the Anti-Monopoly Committee for the last year their wish to adopt the program of the development of competition to be implemented, because at least to some extent it would push the thought, the idea about the inclusiveness of the competition policy. It will to some extent help for people not only in the center but at the local places, for them to understand that without the competition policy nothing is possible. Thank you. And again, I'm apologizing. Just 5-minute technical break. I ask the next participants to take the places. We are not making the break to go on with the discussion. We are going on with the next panel, so please take your seats. Thank you.